Now that our mojo is working, we're going to bring up Mark Hauck from Dykema in Detroit, Michigan. Mark was named Michigan Super Lawyer by Law and Politics and a top lawyer by D-Business magazine. He has written on shareholder litigation in the Michigan Business Law Journal and spoken about alternative legal fees and technology in the courtroom. Mark's practice focuses on business litigation, shareholder disputes, breach of fiduciary duty actions, derivative claims, business breakups, investment advisor claims, accounting malpractice, and franchise termination claims. Here to discuss the brave new world of the 21st century legal fee arrangements is Mark Hauck.
Thank you. Good morning or good afternoon, close to it. I started my legal practice in Louisiana, and I learned very early on it's very, very bad policy to follow a Texas lawyer. So I'll start off with that. I thought that was a great program, Scott. Before we talk about 21st century legal fee arrangements, we have to start with the billable hour. So let's do a brief history of the billable hour. Firms' reliance on the hour as the billing currency really emerged in the 1950s. In the country's early history, legal fees that could be charged were strictly limited by law, and they were generally paid by the losing side. Lawyers relied upon bonuses from satisfied clients or annual retainers to supplement their income. By the early 20th century, lawyers used a combination of billing methods, set fees for particular tasks, annual retainers, discretionary eyeball, the discretionary eyeball method, and then some mixture of contingency fees, but they rarely billed by the hour. In the late 30s and early 40s, state bar associations eager to hike legal fees started publishing minimum fee schedules that set standard rates for different practice services. The schedules might suggest a fee for a contested divorce, for example, or for drafting a will. These supposedly voluntary schedules were often enforced through the threat of disciplinary action. In fact, the ABA's Model Ethical Code, which remained in effect until 1969, actually provided that it was unethical for an attorney to undervalue his or her legal services. The reform of the civil procedure rules beginning in the 1930s dramatically expanded the workload before civil trials by opening up pretrial discovery. These changes were credited with changing us from trial lawyers into litigators. But as a result, the work involved in any given case became unpredictable and subject to the vagaries beyond the lawyer's control, and therefore very difficult to estimate in terms of fees. Over the next few decades, regulation of business activities became more and more complex. Transactions increased in their complexity, all which made the ability to estimate fees necessary for business relationships and litigation related to it much harder to price. In 1975, not all that long ago, the Supreme Court declared that fee schedules were a classic illustration of price fixing that violated the federal antitrust laws. Meanwhile, clients had grown impatient with the non-analytical approach to legal billing and were looking for something that they could be more comfortable with. Against this backdrop, hourly billing appealed to clients and lawyers as a more transparent way to value legal services. Interestingly, in 1958, an ABA committee published a pamphlet called The 1958 Lawyer and His 1938 Dollar. The pamphlet lamented the economic plight of lawyers and their failure to keep pace with the earnings of other professions like doctors and dentists. The ABA urged them to take a more business-like look at their work habits, beginning with time records. The lawyer's, quote, sole expendable asset was their time. The pamphlet suggested that lawyers work 1,300 hours a year, 5 to 6 hours a day, 5 days a week. The good old days. For the next decade, the bar mounted a nationwide campaign to preach the gospel that lawyers who keep time records make more money. By the late 1970s, pure hourly billing came to prevail. Eventually, it became the standard for every variety of legal work. At the end, no one in this room, and quite frankly, no one practicing law today, really practiced in an environment that was not controlled by the billable hour. But it hasn't been without its critics. Robert Hershen, a past president of the American Bar Association, said the billable hour is fundamentally about quantity over quality, repetition over creativity. The financial relationship between clients and lawyers, however, seems to be changing. Pure billable hours as a means of charging for legal services are giving way to novel new fee arrangements. Lawyers, particularly litigators, often are no longer permitted to do whatever it takes to prepare and try their cases. Instead, clients are insisting more on budgets and making sure that the attorneys stick to their budgets or face consequences. The traditional pyramid approach of using a partner and associates and paralegals in a set arrangement is giving way to customized staffing, where individuals are being placed in a position to handle work that's specifically appropriate for them. And lawyers are no longer given complete discretion in terms of making those decisions. My talk today is really intended to explore these changes and to identify what in-house counsel and outside attorneys need to be thinking about as we venture into this brave new world. First, before we get into that, let's consider for a second why these changes are happening. In a nutshell, the billable hour as a means of charging for legal services simply has gotten out of control in the last couple of decades. Law firms did the math and realized that the easiest way to increase profitability was to bill clients more hours. As firms got bigger, associate leverage became increasingly important in terms of profitability. Once the 2,000 hour per year became standard, firms then began to raise their rates considerably during the 80s and 90s. At the same time, the need for legal services grew substantially beginning in the 60s and 70s and continued for some time. Not surprisingly, as a result, legal fees as an expense of doing business became a significant issue for those running America's companies. It was just a matter of time before there was a backlash. In the past couple of years, legal fees paid outside counsel have been flat and actually are trending downward. At the same time, the overhead costs of running a law firm continue to go up. The reasons are many, include cost pressures related to health care, the aging demographics of the associate population and the corresponding increase in salaries, as well as just general inflationary pressures. The bottom line is the status quo cannot continue. It really comes down to a basic choice. If legal spending is flat or decreasing, a law firm must decide if it will accept lower profits, meaning partner and member distributions, or the law firm must develop a more efficient and effective and a productive way to deliver legal services. Those that succeed in the 21st century will flourish. Those that don't will not. So how do we get to that point? Alternative billing arrangements have been around for a long time. A lot of lip service has been given to them over the past decade or so. But what we've had in the past really hasn't provided us with an answer. Traditional fee arrangements, alternative fee arrangements, are usually based upon the flat fee, the success fee, or the blended rate. Some of these arrangements have been successful, many of them are not. The flat fee was often utilized with some sort of a look-back aspect. That would assure that the law firm would neither receive a huge windfall, nor would it be significantly hurt if the flat fee, or when the flat fee was compared to what the firm would have charged based on the hourly rate that was in effect. As a result, at the end of the day, the actual amount that was being charged for the fees really didn't change very much. The success fee approach is based on a traditional contingency fee arrangement, works well, but it's limited in terms of its applicability. Many cases do not lend themselves well to a traditional contingency fee arrangement, such as high-volume defense work. In addition, in many situations, law firms are reluctant to engage in the contingency fee approach because it entails significant risks and unpredictability that they're not familiar with. Blended rates, depending upon how they are structured, often result in actually increasing legal expenses to clients. So if we're going to move forward, we have to think about it from the perspective of what is our goal? Well, quite frankly, it's simple. It's lower legal costs to the client while maintaining or improving law firm profitability. In other words, we want to be able to provide the client with the excellent legal services that they demand, and yet we want to do so in a more effective way. How do we get there? Well, in order to build a better mousetrap, we need to look at how we get to that goal. Number one, we need to improve efficiencies. Number 2, we need to increase productivity. Number 3, we have to change the method of purchasing and delivering legal services. And very importantly, we have to focus on results. Value-based legal arrangement, or fee arrangements, as differentiated from alternative fee arrangements in a traditional sense, are an attempt to link traditional hourly billing with which attorneys and clients are familiar and which they've grown comfortable using to novel fee arrangements which are based on providing value to the client and incorporate incentives to provide quality legal services and the desired result. The last 2 points on this slide I think are especially important. In order to move forward, we have to begin to take into account quality and results, not just time expended. And we have to introduce incentives. I think there's 5 elements to a good value-based billing approach, and I want to go through each of these individually. The first is to define success. Is that winning? Is winning the case success? Sometimes. But other times it's not enough to simply say to win is to succeed. Other times success may be defined by reaching a prompt and reasonable settlement. There are cases where it's more important to obtain knowledge and experience to be applied in future claims of the same type, or to send a message that litigation in this particular area will be expensive and difficult. In order to decide what is success, it is essential for in-house counsel and the outside lawyers to consider both short-term and long-term goals. A one-off commercial case may have no long-term ramifications, but the first of 100 copycat cases will be just the opposite. We can't simply treat every legal assignment as if it's the same. The second important component of this, of a value-based billing approach, is disaggregation, which is breaking the legal assignment down into its component parts. This can be done in a number of ways. It can be done during this, in terms of the stages of litigation or the level of difficulty of a particular assignment. The idea is to allow in-house counsel and the outside lawyers to decide how to accomplish the myriad tasks that are involved in achieving the defined success. Certain tasks may be better performed by in-house counsel, which results in little expenditure of time by outside counsel. Tasks performed by outside counsel should be assigned to the correct member of the litigation team, based on the skill set and level of experience needed, rather than leaving this to the outside partner to decide on the run. Efficiencies can be realized by thinking through in advance and making sure that the right people have been lined up to do the necessary work. A very important part of disaggregation is to eliminate redundancies. Do we really need 3 lawyers reviewing every brief or every discovery response? If the in-house counsel is well versed in the issue at hand, maybe he or she is the person that should review the associate's brief and make the necessary edits. If there's a situation where you have an outside attorney that's been working for you successfully for many years, maybe you need to trust that person that they're going to get that job done correctly and not necessarily have to have a 2-hour phone call reviewing the periods and commas in the brief. The bottom line is this kind of analysis of where we want to spend our legal services should be done and applied through all aspects of the case. There are great opportunities as well to utilize technology. And I'm running low on time, so I'm going to move forward a little quicker here. Project management, I'm only going to talk about very briefly because Lou covered it in his talk, and I thought it was excellent. But the bottom line is project management needs to become part of the program that we use as lawyers. It's a way of making sure that we are doing what we're doing efficiently, prioritizing deliverables, and enhances client reporting opportunities. Another important component is the evaluation process. The process of evaluation should be dynamic. Over time, in-house and outside counsel should develop an understanding of what's working and what's not working and make appropriate adjustments. The evaluation process is not so much one of grading work, rather it's to apply what we have learned to future assignments, and the goal, of course, is constant improvement. Another important component is, in my opinion, is the risk-sharing aspect of the value-based billing. It's probably the most important. The old adage that you get what you pay for is still true. If you're paying for hours, you're going to get a lot of hours. If you incentivize outside counsel to reduce costs and still produce successful results, you are likely to see substantial improvements in your costs, while still achieving the desired results. So how do we get to this win-win situation? Let's look at a few examples. Most value-based billing models are founded on two traditional alternative billing approaches, the incentive fee and the fixed fee. By combining these two approaches together in different ways, we can create a fee structure that aligns the financial interests of the client and outside counsel while encouraging efficiencies and motivating outside counsel to achieve the best possible result. I want to look at a couple. The holdback is actually an idea that's gathering momentum as a value-based billing model. It combines the traditional hourly fee with an incentive fee paid out if the desired result is achieved. The holdback can be used in a myriad of ways. It's limited only by your creativity and the requirements of a given case. A successful result, which is key to the use of a holdback, may be defined by a time frame, resolve the case in 6 months, a fee target, don't pass this particular amount in terms of the cost of the case, bringing a case home within a particular settlement range, trial outcome, or the outcome of a combination of these factors. The bottom line is, as the case goes forward, the bucket gets bigger, and the attorneys know that if they bring the case home where the client is expecting it, they're going to be rewarded. And if they don't, they won't. One of the nice things about the holdback, I think, is sometimes people get concerned with alternative or value-based billing arrangements that you're going to be pushing all the work down to the associates and the partners aren't going to be involved anymore. Holdback gives you incentive. It gives the law firm an incentive to make sure that that doesn't happen. Another interesting approach is the modified fee cap. It involves establishing a cap, and then a target band is established somewhere in the middle. The amount of that band is certainly up for discussion between the parties. But if your fees exceed the band, you get paid a discounted amount, say 25% less than you would normally receive. If you get below the cap, you get to keep the savings. So in other words, if your fee cap starts at, if your target area starts at 50,000, you bring the home case at 40, you get to keep the 10. It creates an incentive to beat or at least not exceed the target. The last one I want to talk about is a fixed fee with a success fee and or a carve out. What's nice about this approach is if you have a number of cases that are similar, the attorneys can be aggressive in terms of their fee proposal if they know they've got some cover in the event of an anomaly. If they know that the rogue case is not going to sink them, that's going to provide them with an incentive to provide you with a better fixed fee arrangement. That's where the carve-outs come in. So for example, if you go into a case and you're expecting to take 4 depositions and it turns out you have to take 10, because that's what's necessary and the in-house counsel agrees, there's going to be an appropriate adjustment there. And of course, a success fee on the end provides the incentive for the attorney to bring the case home within a desired success band. Word of caution quickly, unintended consequences. Whenever you get into any of these newer billing arrangements, you have to be careful that you're not setting yourself up for disappointment or for unintended consequence. For example, you have a success fee based upon, with a fee cap, and right before trial there's an offer of settlement. And the attorney knows that if the settlement were accepted, he's going to end up doing quite well. And if he has to try the case, and even if he does better, the contingency component is not enough to really reward him. You have an unmotivated attorney if he has to go to trial. So you want to be careful with things like that. Okay, and then finally, I just wanted to do some closing ideas here. Is the billable hour dead? No, it's not dead. There are still situations when the billable hour is the most appropriate and best means of pricing legal services, but it is only one tool in our toolbox. It is certainly not everything that we should be looking at in terms of addressing our legal service needs, both as in-house counsel and as the outside attorneys providing them. Thank you very much for your time today. Appreciate it.